Welcome to today's program titled Europe, Better, Worse, or Merely Different, Episode 1, Living with Works Councils. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those who are interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of this webinar recording and materials, along with the CLE attendance form, will be distributed to the attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to turn it over to our moderator for today's program, Martin Hopkins. Martin, please go ahead.
Thank you very much indeed, Kate. Good morning, good afternoon, good evening to everybody who's online. My name is Martin Hopkins, and as Kate says, it's my pleasure to be your moderator today. Our session today is the first in what we plan as a series of webinars focusing upon various distinctive characteristics of the European workplace, all of which tend to contrast with their US and other international equivalents, and which can sometimes cause problems for corporate multinationals, especially for those individuals who are operating in the international space for the first time. And today, as Kate mentioned, we're going to be looking at works councils. We've got a tremendous faculty for you today of people from our European teams who are going to unpack the concept for you, trying to place it in a context, relevant and practical context as they do so, and offering some coping strategies for you along the way. So you'll see those individuals on the screen in front of you. We've got Lawrence Harvey-Wood and Tessa Cranfield, who are European qualified international L&E lawyers who are actually based in Europe. And we've also got Anna Sid, who's a European qualified but US-based international L&E lawyer who's currently working in our New York office. We're going to be talking to you for about 45, 47 minutes, which means that we should have plenty of time at the end of the presentation to pick up any questions that you might have. I think that you have the facility to type questions in as we go, and our commitment to you is that we'll release you at the top of the hour as advertised, and we'll also make sure that if we can't cover all of your questions within that hour, we'll pick any remaining questions up and handle them for you offline. So without any more ado, you haven't come here to listen to me, so I'm going to pass over to Tessa, who's going to get us up and running. Tessa, over to you.
Great. Thanks, Martin. It's good to be with everyone today. So for this first presentation in the session that Martin mentioned, this series setting out the landscape of operating within Europe, we thought works councils was a great place to start. For some might say they're the defining feature of the European workplace. They're quite unique. They're a very different animal to trade unions, which many of you on this call will be used to dealing with in the US or Asia or elsewhere. In fact, it's interesting to understand a little bit of where works councils came from. They've been around for, say, about 100 years. I think they first developed in Germany and Austria. And part of their appeal and the reason that they were adopted was as a counterpoint to trade unions, which were seen as having links to communism, for instance. So they are quite different. There's a few countries where you will find trade union representatives sitting on the Works Council, but they are an internal body, an internal staff forum made up of employee representatives and also with managers and representatives of the company. And they're really tasked with approaching workplace issues and relations with an independent mind. So obviously are coming from an employee viewpoint, but it's not necessarily adversarial, certainly not always adversarial. The idea is that they will try and work with the company in a collaborative way to reach solutions that benefit employees, but also the company. That's the basic premise. And so what is the Works Council's agenda? Well, what you have to take to the Works Council is general day-to-day issues. And as we go through this session, we'll try and bring out some examples of that, not just the big ticket items, which might be when Works Councils come to prominence, in particular for those of you not based in Europe, but there should be a regular dialogue with meetings depending on the country and the company. It might be fortnightly, might be monthly. But with that ongoing dialogue, the idea is to avoid no surprises and also to build some trust and good relations, so that when you come along with a difficult task, like a restructuring, there's something you can build on there. And there's some stability. Works councils, elections, which Anna will talk about in a bit, are fairly well spaced out. So you'll be working with the same set of people often for 2-3 more years. So the relationship is important. Is the Works Council the same in each country? No, the name is the same, but how it's made up, exactly what its rights are when you have to bring it in, there are quite a few differences, which we'll try and highlight for you in the case studies. So we use the same name, but it's not the same, and the rights are not the same in every country, which does need to be taken into account when you're planning projects. And then lastly, as we talk about what the name means, we also wanted to clear up any potential confusion about the topic for today, which is Works Councils in Europe. There's a separate concept, which is the European Works Council. That's something a bit different we won't talk about very much today. And there are 1,000 or more of these European Works Councils in Europe, but they're only for the very largest companies that have a headcount, say, at 1,000 employees or more, but also have in 2 European states, not including the UK now, that also have a headcount of 150 employees in 2 of those states. And in that situation, the employees can ask to set up a European Works Council, which would then be brought in on big projects that affect 2 or more countries, like a big outsourcing or restructuring. So that sits on top of what we're talking about today, which is the country-level Works Councils and day-to-day working with them. And a supervisory board, again, is something else. So this applies in a few countries. Germany is the most prominent, where you have a board that doesn't make the decisions. It's not the management executive board. It sits alongside in the very largest companies where, depending on the country, where the headcount is 50, 100 or more, employee, often Works Councils representative and management representatives sit on a sort of separate board and are asked to give their opinion on topics and have a kind of oversight. Again, we're not talking about that today. That's perhaps a bit more peripheral, and what we're talking about really here is the nuts and bolts of managing your employee relations with the Works Council. So with that out of the way, let's move on to the next slide, and we can get into some of the detail. Lawrence.
Is Lawrence with us?
Sorry, many apologies. I was on mute. I hope you can hear me now. Good morning, good afternoon. My name is Lawrence Harvey-Wood. I am a French and UK qualified employment lawyer based in London. Tess has already spoken a little bit about what a Works Council is versus a trade union. I'll just add a little to that. So Works Councils, typically country by country across Europe, they are internal employee representative bodies. Employees stand as candidates once every 4 years or whatever the local duration of the mandate is, and they are elected by their peers, their colleagues, in order typically to hold regular, say, monthly meetings with management, and also sometimes to hold ad hoc meetings to talk about a new project, an impending restructuring, that sort of thing. By contrast, trade unions, typically they are set up at national level, sometimes by business sector, but by no means always. So they operate externally, but they typically have the right to designate employees in a given company to act as that trade union's representative. And one common distinctive feature of trade unions, which marks them out as a different beast from Works Councils, is typically trade unions have a monopoly on collective bargaining. And that may be at national level. It may simply be at company level. But in a French company, for example, it's quite common to negotiate a working time agreement at company level in order to establish different ways of complying with the 35 hours legislation for different categories of employees. And in France, you would negotiate that agreement with your trade union representatives, although you'd keep the Works Council informed as well. In some companies, the individuals concerned may have 2 hats. They may be an elected Works Council member as well as a trade union representative, but that's not always the case by any means. Finally, typically trade unions are more politically engaged, whereas Works Councils, their focus is very much on the nuts and bolts of the particular company in which they have been elected. So they will be more concerned about how the budget for the staff Christmas party is going to be spent than about making political points of principle. Moving on to our first case study, and the next slide, please. So case study A, we thought it would be helpful just to talk about typical situations, not necessarily situations that crop up every other week, but in the life of a company, events come along in Europe where you go to the Works Council. You might go to them simply to provide them with written information. You might have to go to them in addition to providing written information to ask them to give their formal opinion. And normally that notion is what's referred to as consulting the Works Council. You need to put them in a position to give an informed opinion on a given project or proposed decision. And you need to ask them to give their opinion once you've answered their questions and given them all the relevant information. And when they give their opinion, it may be a vote, it may be a secret vote, it may simply be in favor or against. But typically what consultation means in this context is once you obtain their opinion, then whether it's favorable or not, management can then move on. It can take its decision and the Works Council has no right of veto. There are exceptions to that in some cases, co-determination rights in Germany in some cases, which we'll talk a little bit about later on. But a classic situation, case study A, is an M&A transaction or a takeover bid. Typically a company with subsidiaries with Works Councils across Europe, faced with a transaction like that, is going to have to look at how to comply with local laws in each country that are not all the same by any means. Experience shows that usually France and the Netherlands, I'm afraid, are the worst in class. In other words, they are the hardest countries to comply with consultation obligations, when in reality the parties to the transaction would rather negotiate and sign a sale agreement that is binding on both parties before they announce anything to the markets. In France and the Netherlands, you cannot do that because you have to get to the end of the consultation period and get an opinion from your French and Dutch Works Councils before legally you're allowed to take the decision to proceed with a sale transaction. And because of that, one transactional technique used by lawyers to manage those constraints is simply to exclude France and the Netherlands from the global worldwide deal documentation, to sign agreements that are binding for the rest of the world, but curiously omit France and the Netherlands, then announce the deal, then consult for 2 months or whatever the duration is with your French and Dutch Works Councils, and then sign an amendment to the global deal documentation, the SPA or whatever, in order to add in France and the Netherlands. So that's a common situation in which you might be faced with different domestic Works Council obligations across Europe. I'll pass you back to Tessa now for case study B.
Yeah, and just on Lawrence's example, which is a great one, that's another illustration of the difficulty with global projects of managing the timing, because often you don't really have any certainty. You can't say, we know that if, come what may, within a month or two will be done. There's a couple of countries like Italy where you can say, of course, we only need to run a course for a certain period, but with others, it's hard knowing what the end date would be, and as Lawrence said, the coping mechanisms around that. So a similar theme, one that I know has surprised some clients I've worked with. Rolling out a global policy might seem a very common sense policy to do with behavior, how you use IT, reporting conflicts. Is that something you need to take to the Works Council? You'd hope people are sort of behaving themselves in practice anyway. And I think with a policy, it's an interesting one. I think your starting point should be to assume that you do need to take a policy to the Works Council. But in some countries, that will only require you to inform them. It's a day-to-day matter. And then you'll have to drill down a bit more to see whether it's more than that and you need an opinion or consent. As a rule of thumb, in a number of countries, the key question will be, are you imposing obligations on employees in terms of how they behave, which, if breached, could result in them facing discipline or termination? If so, that's very likely to require a full Works Council process and quite likely agreement, for instance, in Germany. Or is it going to collect their personal information? And that's always very broad in Europe. So if someone is giving information about a colleague, for instance, if they're submitting their own information, if they're signing up for something, that they will be passing on their personal information. And that's often the trigger, for instance, in Austria. So broader than you might think. But again, there are workarounds. If something needs to be done in a hurry, sometimes you can agree that you'll just roll out the policy on a voluntary basis, knowing that if push came to shove, you couldn't discipline people for it, but hoping that in reality, people would play ball, they would see the sense in the policy, and they would go along with it in the meantime. So that's just an illustration of some of the differences between countries, but planning ahead and factoring in Europe, perhaps on its own timeline in a global project. Let's move on to the next slide.
Yes, so moving to following topic, we wanted to highlight what are the notes that are most unusual to non-European business in dealing with the Works Council. So we have listed here a few of them, kind of the major, what we find are generally more unusual for our non-European clients who are not used to deal with the Works Council on an ordinary basis. First one would be funding. So yes, there are some funding obligations with regards to the Works Council. They vary country by country. We might find that generally not direct funding might be necessary, but there are two ways of funding that might be required. First, in the form of paid time off, and I'm going to touch upon that very shortly. But then the other one is, just generally the reimbursement of expenses that might be accrued by the Works Council members in the exercise of the duties. So in their representation duties, they might have expenses in terms of travel allowance, in terms of, other equipment or tools that they're entitled to receive. They have the right for some space or some room for that. Excuse me, access to notice boards, some communication tools like emails or phones. So that has to be all provided and funded by the company. In terms of paid time, and what I was referring earlier, it's, they have not only what we call the credit hours, so they will generally have some time off from work, so paid by the company, to exercise their representation duties. So, out of the 8 hours per day, there will be 1 hour or 2 hours, depending on the size of the company and the number of employee representatives, to exercise just representation duties. But you will find that in bigger companies, and depending, again, on the national rules, there might be full-time employees paid by the company that do not do any productive work, and their day-to-day work is basically to do representation duties. So paid time off, full time for employees, representatives, Works Council members. They will have a dedicated workspace. This is quite global, and it might be in the form of a room. And now with this virtual environment that we're all in, it might be just some virtual access, email correspondence, email areas, but generally they would have the right to use the company premises for the meetings and for the representation duties. So the general example is having a room for the Works Council where employees can go and find them whenever they have any questions and they want to interact with them. And then I'm going to ask Tessa to guide us through the co-determination. What is co-determination, Tessa?
Something that Anna and I often discuss on a Friday evening. Yeah, so it's a strange term. I mean, it tends to generally come up in Germany, but really what it means is agreement. So there are some topics that are seen as so important, and we'll come on to a couple more case studies illustrating this, but they're seen as so important that not only do you need to inform the Works Council and consult the Works Council, and sometimes the obligation stops there with informing or consulting, but sometimes it continues if it's a serious enough issue and you need the Works Council's agreement. And perhaps the slight twist with co-determination is not just do you need a written agreement with the Works Council, that there's a mechanism that you hope you won't have to use, but if you really can't reach agreement, you can escalate it to what's called a conciliation board. So it's a kind of mediation committee made up of employer side and Works Council representatives, just to try and sort of thrash out a deal. But that really is the last resort. If you've got there, then the relations, may be somewhat damaged. It will have taken you, quite a few weeks to have got to that stage. So that is the last resort. But yeah, we wanted to sort of illustrate here that there's that spectrum. Depending on what the changes and what the country is, you might be looking at a range of obligations. Starting with the lightest, which is information, right through to co-determination, which is probably the most onerous. And also, a word to the wary that term might not be used, but if you need to get a positive opinion, for instance, from a French Works Council, or an opinion from a Dutch Works Council, that's almost the same, because they can refuse the opinion. They can, whether you need a positive opinion or not, if they withhold the opinion, you can't move forward. So it's almost like a veto right. So don't be fooled if you see a reference to getting an opinion. It's not as light as it sounds in some countries, and depending what you're planning. And I'll just touch on a couple other points before I hand back to Anna. We also wanted to flag this point about confidential information because it comes up a fair bit with clients, especially clients who are quoted. It might be on a European stock exchange, New York, London. The fact information is confidential and might affect the share price, and so there's a strict duty not to misuse your position as insider or disclose it outside the company. That is not a reason that you can't consult with the Works Council, and that's very clear in every country. So you have to rely on the fact that the Works Council members have signed up to keep it confidential. You might ask them for a further undertaking. You might emphasise that a project is particularly sensitive, but you still have to share the information with them, or if you're going to be in breach. So obviously there are strategies around the timing of when you tell them, the form you give it in, trying to make sure it's not in a form that could leak. But I must say, in our experience, and Lawrence and I can say yay or nay, the Works Councils do take that fairly seriously. Obviously, there's the odd exception if it's a big plan, for instance, that affects the whole future of a site or a closure. Occasionally there's a leak, but generally Works Council members, they see that as a particular role. It's a key part of what they're doing for the company, and so we don't often see that abused in practice.
Agreed, and I might just jump in if I may.
Oh, yeah.
Sorry, I'm not meant to be speaking on this slide, but just to add a related point, some Works Councils across Europe have a statutory right to appoint an expert, an external advisor, usually an accountant in France anyway, who will come in and produce a report on a given project, who will be paid by the company, but whose client is the Works Council. So that's quite a surprising and powerful right, especially because in some countries, including France, the Works Council's statutory expert has extremely extensive powers basically to ask for any documents and information that the expert decides is relevant to what it's going to report on. And that can be very sensitive especially for a listed parent company being asked to produce confidential information that the employing entity in France doesn't even have because it's that confidential. Unfortunately, it is not a satisfactory answer under local law to say you can't have that because it's confidential. So I just thought I'd add that. Thank you.
That's an excellent point, and we had flagged, the role of experts, which Anna will touch on. I'll hand over to Anna in just one moment. We wanted to flag, kind of coming out of that. Hopefully, you'll never be in a situation where you need to discipline a Works Council member. But if you do, or if in fact they're caught up in other changes, for instance, a restructuring, one of the first questions we always ask when we're planning a restructuring is who on this list is protected? And Works Council members are right up there at the top in terms of their protection. So, if you're closing an entire plant, you don't have to leave the Works Council as the last man standing, but it's close to that. So if it's a reduction in a function, the Works Council members will be the last ones left, and there are special arrangements if, for instance, you want to discipline them. Anna, do you want to pick up on that?
Yeah, of course, and that's absolutely right. So they will have this protection in terms of being the last to leave for equivalent positions, but they will also have the protection in terms of disciplines. Obviously, not in the exercise of not only in the exercise of representation duties to prevent retaliation and to grant them the free right to exercise their representation, but of the representation obligations, but also in terms of much higher scrutiny of the disciplinary actions that company might want to implement. And this is granted not only to active employee representatives, to active Works Council members, but also, and then moving to the next topic, which is the election, candidates that are part of the election process will also have some protection. This is, again, the purpose of this regulation is to avoid retaliation for anyone who has participated in the process, even if they were not elected. But we will see them. Some European countries will grant some protection to the candidates that have participated in the process for a certain period, not extensively throughout the duration of the mandate that they were not elected, even if in the end after the election they were not chosen. In terms of the election, this is kind of the general rule, I would say, is this is kind of, again, an employee right. So the employees or the unions, most represented unions, have the right to promote elections, and the triggering factor to have Works Council is that you get disappointment. You get a call for elections, and then the process, the ball starts rolling, and you have to, just allow and let it go to have the election process and have a Works Council being set up in the company. Some countries, though, will have the requirement. This will have to be proactively promoted by the company whenever they reach a threshold. So in France and in the Netherlands, if you have a threshold, a minimum number of employees, then there has to be an election process, and you will have Works Council, even if the employees haven't shown an interest to have employee representation. Although in other countries, as I said, if you don't have elections being called, regardless of the size, you wouldn't have Works Council. And then
you
finally,
may have an intermediate position where you have to hold elections, as in France, but if there are no candidates because no one is interested in being a Works Council member, then you're fine. You just sign a piece of paper and send it to the labour authorities, and you don't have to do anything. You have no Works Council.
Good. Thank you, Lawrence. Yeah. And then I'm going to move. So France, I think, message around Works Council. Engage France Council. So anyway, moving to the last comment, Lawrence has already explained about this, so I'm not gonna get into detail, but yes, Works Council have the right to engage with experts at the company's cost. And these experts, they will have the right to require detailed information, data, to require report, to see accounts, balances, and all of that, but also they might say in some countries, and France is an excellent example of, we want our own experts to take a look at this and to give their opinion, and company has to fund that. So moving on to the next slide. Just, I think this is kind of obvious up to this point of what we have been discussing. These are just Works Council, let's say, is the basis of the engagement model in the workplace environment in Europe. It's not only a nice to have. It's just on the basis of how the workplace has been designed throughout the European countries. It's actually included in the Article 136 of the Treaty of Rome. So it's just in the roots of European countries' workplace regulations. There has to be an active dialogue, and it's covered in different ways. It doesn't have to be always asking for permission, having these expert reports and consultation. It's just a way of having an active engagement with the Works Council. There will be in basically three different forms. We have listed here: information, consultation, and co-determination. So information is just the basic one. There will be monthly meetings where company will just sit down with the representatives and discuss the ongoing day-to-day activity of the company with different topics and rights that, again, are regulated country by country of what has to be shared. But the notion is, discuss the general ongoing of the company. There will be some right to ask for an opinion. So if you're taking some measures, you might have to ask employees, share the information, and ask the Works Council to give their opinion if they want to. There might be other measures where, an active consultation is required, and we're going to see a couple of examples. But the consultation, I think the general notion is not only pretended consultation. You actively have to negotiate, and you have to show good faith in the negotiations to try to reach an agreement and compromise. So we've seen some examples where a company was just sending the proposal, not moving in the proposal, and then closing the consultation, and the court has said, this is not good faith. You didn't move from your proposal. You just said what you wanted to do and closed the negotiation saying what you would do. That is not a good faith consultation, and therefore is not valid. So companies should share this information, should respond to the request, and also should give something depending on what the employees are requesting, of course, and try and do their best to reach an agreement. And then co-determination, Tessa has already touched upon that, but maybe just flagging a practical point, which is there are countries, and we always talk about Germany when we say co-determination, but there are other countries where in practice the law doesn't mandate to reach an agreement. It doesn't say, okay, so you must reach an agreement with the Works Council. It only says you have to negotiate. But in practice, we find a situation where, the scenario is just so hard. It is just so complex for the company in terms of risks, in terms of scrutiny from the authorities, in terms of risky litigation, in terms of bad press, that you're somehow bound, or you're led to this situation where you really should do the best to reach an agreement with the Works Council. And then moving this to the positive side, which is once you have that agreement, once you have that sign-off, you just have that validated. You can implement the message at low risk from a legal standpoint. You already have that agreed, and therefore you can carry on doing whatever company was planning to do. Without the agreement, it's just much more complex, and the press in the different European countries is full of examples of big corporations having to come back, having to reinstate employees, having to take other decisions because they didn't reach an agreement, and the Works Council went to court and succeed. So this co-determination notion is not only where there is an active obligation to reach an agreement, but it might be in some countries where the law doesn't say that you have to reach an agreement, but in practice, you should do the best to reach an agreement in order to be able to achieve the changes that whatever measures you're intending to achieve. And without further ado, we're going to move to a couple of other examples. I'm going to hand over to Tessa to go through another case study.
Yeah, I'm just going to interject ever so quickly there. Thanks ever so much to the faculty for contributions so far. We are just running just a little bit longer than our rehearsals. So if we can just abbreviate these two case studies just a little bit, I think that would help us to stay on track for the rest of the programme.
Okay, thanks for that, Martin. And keep an eye on Q&As as well. So just a couple of minutes on an example of introducing Workday, which has been all the rage in the last 2 or 3 years. So what does that process look like? We wanted to flag here both the kind of the legal side, which is what are the triggers for having to go to the Works Council. You might think it's just an HRIS system. What's the big deal? There's nothing sort of too strategic there impacting employees. But the fact of the handling of the employee data, the concern around that with Europe, and also the fact that salary compensation data tends to show how someone is performing, makes it a very sensitive topic, makes it a Works Council topic. And you can expect that you're going to need agreement in a number of countries. There are some, potentially Austria, depending on the privacy, Belgium, France we've mentioned, where it might just be an information consultation, but that will still take a bit of time. So in practice, how do you plan for that? Number one, just factor it into your timelines. So it will take longer in Europe, and you will need to plan for going to the Works Councils, presenting to them, probably in local language, and meeting with them before you start testing with live employee data. That's important. So it might be earlier than you would think. And we might do 2 agreements to speed things up. We might get agreement to testing and then agree the actual Workday system afterwards. And you'll need that final sign-off before you roll out. So that's just an example of planning up front, timing, and taking into account testing, which, can sometimes be a surprise. Let's move on to the next study, which I think is Anna. Yeah,
so very quickly, I think the basics we have already discussed. This is genuine example of Works Council consultation obligations. So collective downsizing, when there's a collective redundancy process throughout Europe, there's always a consultation obligation. Even in individual redundancies, there might be some consultation obligations. So we find in Germany and also in Spain that you have to serve notice to the employees' representatives when a redundancy, even if it's an individual basis, is taking place. In terms of a collective one, it requires active negotiation. It might require also reaching an agreement, this co-determination that we were discussing. In parallel, there might be other obligations to third parties like unions. They have to be notified in the process in some countries. The timeline varies, again, because some countries will set up a fixed timeline when you have to negotiate, and if you don't reach an agreement, you can move on and make on the decisions. In other countries, that is not set, so you just have to negotiate until you manage to reach an agreement. But it's so important to factor this into account because, you know, the collective redundancies in Europe is one of these examples that you know where you want to get it, but you don't know how much it's going to cost and how long it's going to take. It's just depending on the consultation, and having a good dialogue and a good relationship with Works Council will certainly help. Although, of course, this is going to be, in most of the cases, it's a painful exercise because obviously no one wants to lose the jobs, but it's worth investing in the Works Council relationship and having a good experience one in order to be able to achieve the best results. Couple of notes or recommendations on this is first, this is the basic example of you have to compromise in the negotiation. Negotiations have to be in good faith. And this means you cannot present this as a done deal. You cannot just advertise company has decided to close their factories or their sites in XYZ countries, because you have to propose that and then negotiate and then reach an agreement. So these collective messages or communications saying that the decision has already been taken will only make the process much harder in the European countries and even risk the success of the whole decision. And then secondly, in terms of communication, Works Council will talk with each other, and especially now in this, open communication environment. So it's really important to have a common strategy in terms of what is communicated to the Works Council and the information that is being shared, because we would expect, and we see this all the time when we're advising our clients, that whatever message is given to the employees in the US is immediately known by the Works Council in Spain, in Italy, in France, or wherever. So any agreement that you reach will be known by the others. Good thing in collective process is that, you just have to negotiate with Works Council and reach an agreement. And once the agreement is reached, then, you can proceed. You don't have to sit down with each individual case, each individual employee, discuss, negotiate, agree, and eventually go to court if no agreement is reached. So it would, in the good way, simplify if you reach an agreement and you're able to move on with the measures that are anticipated. But obviously, it's kind of a tricky one, I would say. So moving on to the next slide, seeing things in the round, I would invite here Lawrence to tell us a few examples in France on how Works Council relationship works.
Thanks, Anna. We've got the first bullet point here of availability bias. You're probably wondering what on earth that is all about. I know I did. All it means is really don't judge a book by its cover. The idea is probably the only times you hear about Works Councils in Europe doing anything is when they're doing something particularly aggressive or crazy. You may remember in France that once every few years it hits the press that Works Council members have decided to take management prisoner and abduct them sometimes for several days to try to make a point and persuade management to rethink a proposal such as a collective dismissal. It happened a few years back with Air France, and indeed there was even video footage of an unfortunate Air France HR director who'd had the shirt literally ripped off his back as he tried to escape the clutches of these demonic Works Council members. But, are Works Councils across Europe typically doing that on a weekly basis? Of course not. It's just that you only hear about extreme situations, grotesque caricatures of that sort. And certainly, in 20 years of practice in the French employment law arena, I've seen some fairly strange things. I mean, one example, which I fortunately wasn't actually advising on, but a big US multinational with a large subsidiary in France distributing very sophisticated X-ray machines for medical purposes. It provided its technical engineers in France with detailed manuals to help them to repair these machines when they went wrong in hospitals. And these manuals were several hundred pages long of very, very technical information in English. And the engineers were fine using them, but the Works Council decided to sue the company on their behalf just to make a point that this is France, so you should be providing documents in the French language. And because there is a provision in the French Labour Code, which is a mighty tome, here it is, 2 kilos of it, there is a provision saying documents which employees need in order to do their work must be in French. So the Works Council won, and they got damages of over €500,000. But once more, is that really typical? No, not at all. And I think, to give you a more balanced impression, we should be explaining that actually sometimes Works Councils in Europe are a thoroughly positive communications tool rather than a permanent thorn in the side of management. If you're trying to communicate to employees about a restructuring where everyone is anxious and worried for the future, the fact of being able to engage with the Works Council on the detail of the proposals and win their trust by showing that you're really trying your best to make things as smooth and positive in this difficult situation for your employees as possible, that's a great start to being able to implement change management in an effective and timely way. Anna, I don't know if you agree with that or if you think I'm talking rubbish, but please jump in.
No, absolutely. I think that's kind of the approach, and we see this in the other countries. I mean, of course, there are difficult situations where Works Council will do their best to make noise and to act crazy. That's what we see in the press. That's what is in the news, obviously. Good communications, great negotiations, compromise. It's not in the news. It's not exceptional, but luckily, that's the majority of the cases, I would say, in my experience. So I think the best tip is, just invest in good people, good representatives from the company to compromise, to be collaborative, to have good relationships, and to build in a trust environment or relationship with the Works Council. Because if you have that day to day, then when you get to the difficult measures, whenever they come, and if they do ever come, obviously, then you already have that. And if not, the day-to-day ongoing engagement that the European employment laws provide are going to be much easier. And you find that many situations, it's just when we see companies that are lucky enough or have invested in good talent to manage the employee relations and to manage the discussions with the Works Council are just able to achieve things and to look for the company's success in long term much easier than the companies that have not.
And if I can add, I think we're okay. If I can just add briefly to that, I think we've all between us seen examples where a Works Council has added value. So, for instance, where in particular if there isn't so much of a local management of HR on the ground, often they can add quite a lot of insight into individual employees' motivation, into their situations. They can help to reach people. So I think we've all seen the Works Council help to push things on from that viewpoint. I've also seen projects, often if they're sort of quite technical, they involve how a system will roll out, where actually there's been a genuine dialogue and the company has said, okay, actually, we didn't think about that. It's not contentious. Let's take that on board. And they've ended up with a better product. I won't say it's always the case, but we've certainly seen that happen in practice. So, yeah, just exactly, we're trying to sort of balance out the picture here. And I think often where the situation becomes more adversarial or the Works Council becomes more problematic, it can be because the timelines haven't been designed with them in mind. And so we're trying to get things through very quickly. or we don't quite have the information. It's a centralized plan, for instance. And I think often that's where problems come from. Whereas if you've got the luxury of being able to allow time in the timeline and get the information you need to start on the right foot, often we find the process can be, productive. It might be time consuming, but productive.
Mm-hmm. Absolutely agree. So I think we can move to them.
So Kate, if we can flip to the last slide, I think. Thanks very much indeed to the faculty for working hard to get us back on track. And I think it is really important and really helpful to try and balance these things out and to make sure that we kind of emphasize that these dealings can occasionally, well, not just occasionally, can very often be very positive and very collaborative and very supportive of corporate interests. So just to bring this back to where we started before we dive into some Q&A, we posed a question at the front end of this presentation as to whether this regime was better, worse, or simply different to that which we encounter occasionally in the US and elsewhere around the world. So I'm going to go across the faculty one by one. Anna, what do you think? I think it's a better system, a worse system, or simply a different one?
I think it's just different. So generally, I mean, it's just a different environment. And going to my previous point of, it's just in the roots of the European workplace workplace rules. So once you understand that there's information to be shared, there's dialogue to be had, there's a body there, Works Council, that you have to take into account for the company's ongoing decisions, then you can just move ahead. I think it's not a matter of saying, well, I like it or I don't like it. It's just how it is in Europe. So it's just the house rules that we have to stay with. But once you understand that, it's just it's not necessarily bad, to be honest. That's my opinion.
Tessa, what about you?
Yeah, well, of course, I always agree with Anna. I agree with that, but I just think in the context of Europe, where there is expected to be more dialogue, you see it in the politics as well. The Works Council is effective. I must say things do take longer. So, when we do our project plans, you always have the US first, the UK following shortly afterwards, and Europe to follow. That's something we live with, so I can't say better, but we are operating within the house rules. I like the way Anna puts it. We can still get things done.
And finally, last but not least, Lawrence, a man literally with feet in both camps here, a man qualified and practicing in the UK, but also with a kind of a continental European qualification as well. So you kind of see both sides of this. What's your view?
Fine, thanks, Martin. Yeah. So I started life as a UK employment lawyer in London, and after a few years, my previous firm, which I was at, agreed to second me to their Paris office for a few months, and I stayed for 17 years. So that shows you what I think of the situation. I love French employment law. I find it much more interesting than UK employment law. Sorry, Tessa. And part of that, part of the richness of the subject matter in France is, of course, the relationship with the Works Council, which is challenging sometimes, of course, but it exists for a reason which makes a lot of sense to me. And it's a fact of life. But one which is not all bad by any means, as we tried to illustrate a few minutes ago. Thank you very much.
Thank you very much indeed. Thanks, Lawrence. Yeah, so the concluding point on that slide is around Works Council avoidance or being Works Council free. It's not the kind of thing that we tend to hear as often nowadays as maybe 15, 20 years ago, as global trade really was beginning to pick up speed. But it's certainly a challenge that I've had on many occasions in my career from corporate multinationals in Europe or Asia who just did not have any empathy at all with the notion of a Works Council and were as vigorous in their pursuit of a Works Council-free environment as you sometimes see in trades union-free environments elsewhere in the world. Simple fact is that that's just not really one of the available options for all the reasons that Anna and Tessa and Lawrence have identified. This is just built in at the very most fundamental level of European workplace regulation, and being in a works council and having a works council representation is simply a right in the vast majority of European jurisdictions. And like it or not, it's not something that you can excuse yourself from. And for the reasons that our faculty's identified, maybe it's also not something that you should see as the same threatening presence that you might occasionally have experienced with a trade union elsewhere in the world. So that covers what we wanted to talk to you about this afternoon, this morning, this evening, depending upon where you are. We do have 10 minutes left for Q&A. I'm going to demonstrate my inadequacy here. I can see the questions. I'm not sure if my faculty colleagues can see them. I think they probably can. Can one of you please nod at me if you can see it? Yeah, there you go. Lawrence, thumbs up. Good man. So the first question, if the Works Council is hiring somebody who's not an employee of the company, do we need to provide the same benefits as to our employees in country? Do I have a volunteer as to who might like to pick that one up, or shall I?
I'm happy to take it.
Benevolently apply it to somebody. Lawrence, here you go. Lawrence is right in there.
I've never been asked that question before in France or elsewhere, so I thought I would jump in and get it wrong before anyone else has the chance to do so. My off-the-cuff reaction is that under French law, at any rate, the general principles of equal treatment are normally limited to the legal entity that is the employer of the workforce. So, there is, I think there's an exception to that specifically set out in the Labour Code for temporary employees. They, of course, their employer is the temp agency in France, not the user host entity. But you do have some obligations to pay them on an equivalent basis to the person in the host entity whom they are replacing, if there is anyone of similar qualifications. But that's very much an exception where you are applying equality principles between two different legal entities. Normally in France, you're only looking at equal treatment principles within a single legal entity. Anna, Tessa, I don't know if you want to jump in.
I mean, I think that's absolutely right, Lawrence, across Europe. I mean, reading the question again, I don't know quite the scenario we're talking about. The Works Council wouldn't be entitled to hire to sort of engage an employee. They could bring in an expert, but if it's an expert, in France, they would be a sort of consultant, and it would be a fee.
I think they can in Germany as well. It's very unusual. I think I've only come across it once or twice in, the 89 years I've been practicing, but I have seen it very occasionally. And I think, Lawrence, I think you've seen it in France as well, Lawrence. I suspect it might be a little bit more commonplace there.
Yeah, well, it's certainly not commonplace, but I think, and I can't think of any specific examples, but I should think a company like, the company that used to be called Gaz de France, or a company like Airbus, which, in a single legal entity has 20,000 employees in France, the Works Council's statutory budget entitlement in France is a percentage of the total annual payroll costs. So if you have that many employees, the Works Council has a huge budget and it can have its own employees to work full-time for the Works Council.
How interesting. I'd like to learn.
Yeah, and I think that you'll find, for the reasons that Lawrence identified, that is not limited to France, but I think it will be a fairly rare event in most other jurisdictions. I don't know, Anna, have you ever seen it in Spain, where a Works Council will have its own separate employees?
No, it's not like that in Spain. But they would have, again, right to bring a union to act as an advisor to the meetings, but then they're not allowed to hire employees.
If you have 11 employees of a Works Council in France, then you would have the dizzying prospect of a Works Council having to set up its own Works Council. But I've never seen that.
Okay, so there's one other question that I see, which is an inquiry as to whether there's a resource that lists all European countries and threshold numbers of employees. that trigger employee rep and or Works Council requirements. There are loads of them, and I think what I would suggest we do, rather than try to address that now, because that would require some Googling, if Julie is happy, I will take that offline and email a couple of suggestions to you separately, because the challenge is not finding a resource, it's finding an accurate and an authoritative one. But I'm happy to take that as a kind of a takeaway. Okay, so I don't see any more questions, which means that, thank you for that, Julie, just spotted your reply. I'll pick up with you separately. The last piece of information that I need to communicate to you is the CLE code. So if you all have a piece of paper and a pencil or the electronic equivalent of it to hand, it's 2 letters and 4 digits. So it's SS, so Sierra, Sierra 8701. I'll just do that again. Sierra, Sierra 8701. So with that, thank you very much indeed to the faculty. Fantastic contributions, everybody, but thank you mainly to the audience. I wish I could see you, but I can't. But anyway, I know you're there. Thank you very much indeed for dialing in. I hope this was useful, and you never know, maybe we'll see you again when we start with edition 2, 3, 4, and who knows, maybe even beyond that in this occasional series. Thanks for your time, everybody. Have a great remainder of your day.